Sit wherever you want. See, that I went right back to where there was stuff. Yeah.
Preacher.
Welcome back, ladies and gentlemen. In a few moments, I'm going to read your preliminary instructions to you. We have handed you out notepads. If the bailiff didn't tell you, please put your name on the first page of the notepad. Please don't write on the binding because we reuse these things. The notepads will be for your usage here in court. When you leave during the week, you'll leave your notepads here. You only really take them with you when you go for deliberation. Okay, so while you're here, you take notes, and then you'll leave them here. We'll collect them up and lock them up for you so no one can see your notes. Then you'll take them with you to deliberation. The reason that is because, and if you listen carefully to this, you can't begin to deliberate the case until the very end. So if you were to go back as jurors anytime during this trial and start talking about what you saw during the trial, or started, figuring out things, that's a form of deliberation. You can't do that. You have to wait until you've heard everything to start really deliberating the case, okay? And so that requires a little bit of discipline, that you don't all go back and say, hey, did you see that? What'd you think? You can't do that, okay? But so you'll wait till the very end, and so you won't need your notebook till the very end. But we will safeguard them for you, and when they're done, they go from the bailiff to my assistant, who shreds them all. I don't even pick them up or look at them in any way whatsoever. Okay? So, if you listen carefully to me. Ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Herbert Swilley. This is a criminal case. Herbert Swilley is charged with first-degree murder. The definition of first-degree murder will be explained to you later. The state's charging document, which is called an indictment, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Herbert Swilley in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the instructions are given, the alternate juror will be released, and then you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instruction on the law by the judge. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence in the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave him or her at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact number will be provided for you if you need one. The case must be tried by you only on the evidence presented during the trial in your presence and the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies to whether you're in a courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about the case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries of your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties, likewise, have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that the defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. Actually, here we're taking to my assistant. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Ms. Burnt, you ready to proceed?
Yes, I am. May it please the court?
Yes, ma'am.
Counsel? Good afternoon, members of the jury. Money and control. Those are the two things that the defendant, Herbert Swilley, stood to lose as his marriage to Tim Smith fell apart and Tim planned to leave him. But instead of letting Tim go, the defendant savagely murdered him. He beat Tim in the face, then he placed a ligature around Tim's neck and squeezed it so tightly that the blood vessels in Tim's eyes burst and his neck broke. Tim Smith was 59 years old when he was brutally murdered. Tim was loved by everyone who knew him. He was warm, welcoming, and made people feel better about life. One of Tim's passions was making sure there was good assisted living facilities for seniors. Tim was the executive director of Brookdale Senior Living, which was an assisted living facility here in Ocala for senior citizens. His position, executive director, was a high-level position with a salary well over $100,000 a year, plus bonuses. Tim had been the director there about 7 years before he was murdered. Now, the assisted senior living healthcare industry was relatively small in the state of Florida, and Tim was well regarded and well known in that industry. Tim had a great life. He had a good job, he had a nice home, and a diverse group of friends that adored him. But there was one glaring problem: his relationship with the defendant, his husband, Herbert Swilley. Herbert and Tim have been together for about 15 years and married for 8 of those years. But before they began their romantic relationship, the defendant was married to a woman named Angela for many years. The defendant and Angela had one child together, a daughter named Jordan, who was born in 2003. Now, Tim and the defendant had been friends for about 4 years before their relationship turned romantic, and the defendant left his wife and moved in with Tim. And Jordan was about 8 years old when this happened. Now, Tim and the defendant lived in several different places before they settled on a home in southeast Ocala. Now, the home was on a nice-sized piece of property. It was 4 bedrooms, 2 bathrooms. It had 2 separate living rooms, It had a garage outside and a big shed outside as well. And on that property, they had 2 cameras. A Ring doorbell camera that was on the front door, and then a camera that was high up on a pole that faced their shed and their garage. Now, in the beginning of Tim and the defendant's relationship, Jordan lived with her mother. But when Jordan became a freshman in high school, she decided to move in with Tim and the defendant. Tim and Jordan were very close, and they had a special relationship. Jordan considered Tim a second father. Now, in addition to their main home that I just told you about, Tim and the defendant rented a small 2-bedroom apartment that was about 2 miles away from their main home where they lived. Tim and the defendant had an open relationship. They had sex with other men together, and they had sex with other men separately. And they would meet these other men on dating apps, mainly Grindr and Adam for Adam. Now, they also liked to role play and do fantasy things in their sexual relationship. So in this apartment, they put things like a sex swing, a massage table, and they had a toolbox that had different kinds of sexual paraphernalia in the room. This was something that they thought was fun and they both enjoyed. And the reason they got the apartment is because Jordan was living at home with them, and they wanted to keep this away from her. Now, Tim was the breadwinner of the family. While he had a high-paying job as the executive director of Brookdale, the defendant, in contrast, was a handyman. The defendant and Tim liked to do things. They liked to travel. They liked to buy things like motorcycles. And they spent Tim's money as fast as he made it. And the defendant could not afford to live this lifestyle without Tim's salary. Now, the defendant was painfully aware of this fact. And over time, he grew bitter. And he came to resent Tim for this. Now, the relationship between Tim and the defendant had been declining for years, and had just gotten worse in the month leading up to Tim's murder. The beginning of the end was when they both stopped drinking. Tim and the defendant had been heavy drinkers for most of their relationship. But somewhere around 2019, Tim joined Alcoholics Anonymous. The defendant followed Tim's lead and joined several months later. Tim embraced the AA lifestyle. His chapter's name was Happy, Joyous, and Free. He led many meetings, he sponsored countless people, and he went to meetings up to 5 times a week. Now, through AA, Tim cultivated a very close group of friends. And these friends would go out to dinner after meetings, and they would occasionally go to brunch on Sunday. Now, once the drinking stopped, the problem is the arguing started. They started arguing all the time. It had gotten so bad at home that Jordan would leave home early and go to work at Lorito's Italian restaurant just to get away from the argument at the house between Tim and the defendant. Now, Tim knew the marriage was over, and he was going to leave, and he knew it couldn't be fixed. And in early March, a professional recruiter reached out to Tim and said, hey, there's this job for an executive director at an assisted living facility for seniors in DeLand, and we're interested in you. Tim thought, this is my chance. I can leave the defendant, get a new job, and get away. Tim sent his resume to the recruiter, and he did an hour-long video interview that was recorded over Zoom. This interview was sent to the regional director for this assisted living facility in DeLand named Nina Corsi. And she looked at it, and she was very interested in Tim. And he was very close to getting this new job. defendant knew all about it, was not happy. He knew if Tim left and took this new job, he wouldn't be able to stay in the house they lived in. He wouldn't be able to have the lifestyle that he had become accustomed to. And he started telling other friends about it, how he wasn't happy, and Tim was going to try to take this job. And he became very angry. 5 days before Tim was murdered, the defendant told a friend named Daryl Levine, if Tim thinks he's leaving me and taking a new job in DeLand, he's got another thing coming. He also told that same friend, Jordan and I loved Tim. And this really bothered Daryl, his friend. And it stuck out in his head because it was in the past tense. So things got worse, time went by, and the defendant had to face some cold, hard facts. It's the end of March now. He knows Tim's leaving him. Tim's moving to another city to get a new job, and he can't support himself without Tim. He's mad. He feels cheated. He thinks Tim owes him, and he's not going to let Tim leave him like that. So to the defendant, there was only one option. Tim had to die. Because that would solve all his problems. Because Tim had a life insurance policy worth $333,000. Tim also had a 401 retirement plan with $48,000 in it. And guess who was the beneficiary of both of those things? The defendant, Herbert Swilley. $381,000 surely would go a long way for the defendant once Tim was dead. So the defendant decided, I'm going to kill him, I'm going to murder Tim, and he picked the date. March 23rd, Thursday of 2023. And this day, at this time, Tim was closer than he'd ever been to getting that offer for that new job. Because Friday morning was one of his final interviews, which was going to be with Nina Corsi, the executive director of the facility of the new job. So Thursday was the day. And the defendant put his plans in motion. Now the defendant and the victim were both physically fit people. And the defendant knew he would need some help taking Tim down. What was the easiest and quietest way to do that? It would be to drug Tim. That way Tim couldn't fight back. That was part of his plan that day. So that Thursday, that morning, everybody goes to work, Jordan, the defendant, and Tim. They come home that evening, they all have dinner together. They end up watching a movie, the three of them. Around 9:30, the defendant and Tim go to bed, and Jordan goes in her room. Sometime that evening of the 23rd, the defendant secretly overdoses Tim with diphenhydramine. Diphenhydramine is in medicines like Tylenol PM and Benadryl. Diphenhydramine is the ingredient that makes you tired in those medicines. Now, a normal dose of diphenhydramine, if you tested somebody's blood, would be 55 nanograms per milliliter. When they tested Tim's blood after he died, his level of diphenhydramine was 2,000 nanograms per milliliter. Tim was probably not even awake when the attack began. but he certainly couldn't fight back. The defendant beat him. He had a black eye. Tim had bruising on his face. He had cuts and swelling. And then the defendant put that ligature over Tim's neck. And he squeezed it so tight and for so long that he broke Tim's neck. And you will hear that the type of injury is called a hyperextension type of injury, which means Tim's neck was bent backwards this way until it broke. Now the next part of the defendant's plan, he already had it ready. I'm going to say that Tim left in the middle of the night to meet somebody for sex at the apartment, and that person's who killed him. So we had to start getting that plan ready. So after he killed Tim, the defendant put Tim's body in his own white truck. You'll see pictures of this white truck. It's distinctive because the whole truck is white, except for the tailgate, which is black. Now the defendant knew also, hey, I gotta take Tim's phone as well with me to the apartment, because Tim's not gonna go meet somebody to have sex without his phone. So he takes Tim's phone as well. And then he says, okay, also Tim always takes this small black bag that he has with him when he goes to the apartment. In the bag are Tim's wallet, his keys, and a few other things. So the defendant gets that bag also. He puts the bag, Tim's phone, and Tim's body in his white truck, and he drives over to the apartment. And from there, he stages the murder. He puts out 2 bowls and a bag of chips, so it looks like Tim had somebody over. He takes off Tim's pants, leaves him on the floor in the bedroom, half naked. He takes bleach and sprays Tim's body and all around Tim, and takes some towels to make it look like somebody tried to erase the DNA. Then he leaves Tim there with the bag and the phone. He gets in his truck and he goes back home. But now he has to get Tim's Jeep over to the apartment, because obviously Tim had to get there somehow. So he leaves his white truck at their house. He gets in Tim's Jeep. Tim has a white Jeep. And he drives Tim's vehicle to the apartment. He leaves Tim's vehicle at the apartment, goes inside, and puts the key to Tim's Jeep in that black bag where Tim would have put it. But how's he going to get home if he leaves Tim's Jeep there? Easy. He's physically fit. It's a 2-mile walk in the middle of the night in March. He walks back home. And when he gets home, it's around 3:26. First thing he does, access the Ring doorbell application on his phone. He's got to get rid of all that footage. It's going to show him moving everything around, moving Tim's body and setting everything up. So he deletes that. Now we're well into Friday morning, the 24th, by the time he does all this. So he normally gets up and goes to the gym at 4:40. So he's going to go along like a regular day, like nothing happened. He gets up, leaves for the gym at 4:40, gets to the gym at 5. Stays to the gym till 6 o'clock, and goes home. Takes a shower and changes, then leaves again. And he goes to Lowe's. And then, oddly, his next stop is the dump. At 7 in the morning, right when they open, he's there with his truck and his trailer. After he goes to the dump, he goes back home. And now he goes home because the dog groomer's supposed to be coming. And he wants to make sure that Jordan's awake to let the dog groomer in. But ultimately, Jordan will end up to be one of the many mistakes that the defendant made. Because remember, Jordan was home when he killed Tim. And even though Tim was drugged, surely there was some noise. So when Jordan woke up that morning, she asked him, "Where's Tim?" He said he didn't know. And he asked Jordan, "Did you hear anything last night?" And Jordan said, "I thought I heard a door or something." And he said, "You didn't hear anything. That's all you need to remember." Jordan started to ask some more questions, but he quickly shut it down and said, "If anybody asks, I was home all night." Jordan was upset, confused, and thought all of this behavior was very suspicious. But the defendant again went on with his day as planned. He left, he went down to the villages, and he did some of his handyman work that he was doing in the villages. In the meantime, people at Tim's work, this is Friday now, are getting concerned because Tim doesn't come to work. And he always comes to work, or he lets them know if he's not coming. They text him throughout the day and ask him some questions related to work, and he doesn't respond. And this is not like Tim at all. So they get concerned. And one of his close friends and co-workers, Tammy Warner, calls the defendant around 4 o'clock and says, "Hey, Tim didn't come to work today. What's going on?" The defendant, "Oh, I don't know. I don't know where he is. I'm going to run over to the apartment and see if he's there." So he goes over to the apartment. Tim's Jeep's there. He doesn't go in. He calls Tammy back. "Well, his Jeep's there. I lost the key, or Tim took it. I don't have the key, so I can't get in. But his Jeep's there." Tammy says, "Well, we need to do a well-being check. Call the sheriff's office." "Okay, I'll call the sheriff's office for a well-being check." He calls the sheriff's office. This is a little after 4 o'clock. "My husband Tim didn't go to work today. His Jeep's at an apartment we own." They say, "Okay, we'll send somebody out." The sheriff's office sends a deputy out. This is Friday, around 4:30, 5 o'clock. The defendant's not there, but the deputy gets there, and the deputy calls the defendant on the phone. The defendant's calm, no sense of urgency, and says, "Oh, my husband didn't go to work today. We have this apartment. I'm not really concerned. I don't have a key, so I'll try to reach the landlord to get a key to go in." Because the defendant had no sense of urgency, was calm during the call, and didn't tell the deputy anything that would give him cause to break down the door to see if Tim's in there, the deputy says, "Okay, well, you're not telling me anything that can let me go into the place, so if he doesn't come home tomorrow, you can do another well-being check. Call us back." "Okay, fine." So the defendant then, that Friday evening, the 24th, goes to an AA meeting around 5:30. And everybody that sees him there knows something is wrong. They describe him as red-faced, sweaty, nervous, fidgety. And they ask him after the meeting, "What's going on?" And he says, "Tim and I got in a fight. I don't know where he is. He's not responding to my texts or my calls. And his Jeep is at the apartment." And so a couple friends say, "You're a handyman. Take the lock off the door and see if he's in there." The defendant's response is, "I'm not technically on the lease, so I could get arrested for burglary, so I can't go in there." Okay. But of course, all of Tim's friends are now very concerned. The people from work, the people from AA, they're calling and trying to reach Tim. So now we go into Saturday morning. Still no sign of Tim. The defendant goes to work. Back to the villages to do some handyman work. In the meantime, all of the friends are calling him. Have you heard from Tim? They are panicked. He is not. Where's Tim? Have you heard from Tim? You've got to get into the apartment. Okay, fine. I'll call the sheriff's office again. He calls the sheriff's office around 10 that morning. Hey, can you come back and do another well-being check? I've gotten in touch with the landlord now, and we have a key to get in. So this is around 10 in the morning on the 25th. They send another deputy out. And the deputy comes out. The defendant is already there at the apartment with the landlord, Jack, and they have the key, but they're just standing there. The deputy goes up. Hey, what's going on? Hey, that's my husband's Jeep there. I haven't seen him in 2 days. We have the key. Okay. Deputy takes the key, goes into the apartment by himself. And of course, we know what he finds. He finds Tim dead on the floor with the ligature marks around his neck. They're clear and defined and black, and they go around his neck. And he doesn't have any pants on, and he's been beaten. And of course, the deputy immediately suspects that it's a murder. So the deputy goes outside, and the defendant says to the deputy, "Is he in there?" And the deputy says, "Yes." And he says, "Is he okay?" And the deputy says, "No." He doesn't cry, break down, ask one question about what the deputy found. He doesn't say, what happened to him? What kind of condition did he in? Is it a suicide? Not a question. The deputy tells him, "I'm going to call major crimes. They're going to be on their way." He never asks, "Why are you calling major crimes? What did you find in there that would make you call major crimes?" He says, "Okay." And the deputy says, "Give me a little rundown of the story." He tells him the well-rehearsed story. We went to bed at 9:30. I woke up the next morning. I thought Tim was still there. Maybe I was wrong. He didn't go to work. I haven't seen him since then. So the deputy calls his sergeant, and they call major crimes. And they call forensic crime scene technicians. And they put yellow crime scene tape up, and they mark off the whole apartment. And the detective, Daniel Pinder, is assigned as the lead detective in the case, and he comes out, along with many other officers. And they spend hours processing the apartment, swabbing things for DNA, checking for fingerprints, taking photographs. And they spend all day, almost all day, Saturday doing that. Now on Monday, the 27th, the sheriff's office has a briefing, which means they get together all the detectives together to talk about this case. And Detective Pinder gives them a rundown about what they have. And they start assigning different detectives things to do. So they give some detectives, they say, "We want you to go back to the area around the apartment. Talk to all the neighbors. See if they know anything. Check everybody that lives around there for cameras. Ring doorbell cameras, anybody that may have any footage." Okay, we're going to have those people do that. Send some detectives to where they live, their main residence. Talk to all the neighbors there. Check for cameras from neighbors that live right next door. See what that shows us. They send some detectives to all the businesses that are between that 2-mile stretch between the residence and the apartment. Go to every single one of those businesses and see if they have any video surveillance. Also, check the trash. They check the trash at the apartment complex, and they check the trash there. And they start interviewing people. So all the detectives are doing all of this work. And while this is happening, the Marion County Sheriff's Office puts out 2 press releases that say, "Hey, we're working on this murder. If you know anything about the murder or about Tim Smith or Herbert Swilley, please contact us." And the floodgates open at this point. Friends of Tim and the defendant start contacting the sheriff's office. And what they paint is a picture of a marriage in trouble, with one of them being very angry, the defendant, and not happy with Tim. And this is upsetting to Detective Pinder, because the defendant told him everything was fine with the relationship. Everything's great. We're not fighting. We have a great marriage. But that is not what all the friends, co-workers, and everyone else started telling the sheriff's office. One of their friends, a close friend of both of them, named Candace Baker, called in, went down to see the detective Pinder. And she said, listen, I went over to the house on Sunday, the day after they found Tim's body. And from the moment the defendant answered the door, I was upset because of how unconcerned he was that Tim was dead. But more than that, when I got inside the home, he was throwing everything of Tim's away. There was a big garbage can in the pantry. All of Tim's food and snacks and vitamins were in that. All of Tim's knickknacks were in the garbage. But what upset her the most was there was a stack of framed portraits on the table. And they were professional portraits taken of Tim and the defendant and Jordan. And he was going to throw all those away. And he told Candace, I can finally have the house the way I want it. So, even though they were getting all of these tips and things, statements from people that knew them, Detective Pinder still made sure he pursued any other potential suspects. If somebody called in a tip and said, hey, you need to check this person out, Detective Pinder did it. The forensic crime scene processing turned up 2 other men's DNA and fingerprints on some lubrication bottles that were in that apartment. Detective Pinder located them and were able to rule them out as suspects. So he was running down every lead he possibly could. As he's doing this, more and more information is coming in. He learns about the insurance policy and the retirement fund. And he gets all that paperwork. And he learns from the insurance company that the defendant is calling all the time trying to get that money. And then he talks to more friends who say, yeah, we've been talking to the defendant, and he keeps telling us how he can't live without that insurance money. And he really needs that insurance money. And he also told one of their friends, hey, I'm planning a big trip at the end of the year once I get that insurance money. You want to come with me on this big trip? Detective Pinder's obviously concerned about this. And then Detective Pinder gets the toxicology results back, because they take a while to get back with Tim's blood. And he finds out about the extraordinarily high level of diphenhydramine in Tim's blood. As he's getting all of this information in and all this evidence, it's all pointing to one person as the murderer of Tim, and that's the defendant. So for the next 6 or 7 months, Detective Pinder spends countless hours going over all of the video that was received from those businesses that were on the roof between the apartment and the residence, and the videos from the neighbors. Because there's a lot of it, and it takes a long time to go through it all. He goes through all of that. He also painstakingly goes through the defendant's cell phone and Tim's cell phone, which will have geolocation information to tell you where did that phone go. And also tell you, was somebody on that phone actively using it, or were they not? So after Detective Pinder goes through all of those cell phone records and reports, and all of the videos from the businesses and the neighborhood surveillance, he is able to prove what the defendant did that night of the 23rd into the 24th, and where he went, based on those records and those videos. And what can be proven from those records and the videos that you will see is that in the evening of Thursday the 23rd, nobody left the house. The white truck of the defendant's was there. Tim's Jeep was there. Both the defendant's phone and the victim's phone were both there on the 23rd. But in the early morning hours of the 24th, Tim's phone travels from the residence to the apartment and is at the apartment at 2:12 in the morning on Friday. Coincidentally, what else travels from the residence to the apartment at that exact same time? The defendant's white pickup truck. You'll see a video of that. The truck is there for about 20 minutes. Then the truck travels back to the residence. Then Tim's Jeep, Tim's white Jeep, leaves the residence at 2:40 and arrives at the apartment at 2:45. And we know that, and you'll see a video of that also. And we know then, after he drops the Jeep off at 2:45, he's going to walk back. And you'll see a video from the Marathon gas station that's right on that road between the two that shows somebody walking right towards the direction of the defendant's house. And Google Map puts the time it would take the defendant to walk from that video to his residence, having him arrive at the residence at 3:26 a.m. Well, what else do we know happened at 3:26 a.m.? You will see the cell phone reports that show the defendant was accessing the Ring doorbell camera at 3:26 a.m., right when Google Maps puts him arriving at the house. After he accesses the Ring doorbell camera and deletes all the video footage, he goes on Facebook, and then he goes on Grindr. And he's on there until he leaves to go to the gym that morning at 4:40. And remember that every detective that talked to the defendant, he told every one of them, I never left the house. I was asleep the whole night until I woke up to go to the gym. The evidence and the videos will show that that is not true. And when you hear from all the witnesses in this case, that will tell you the things the defendant said about Tim, how he felt about Tim, how he wasn't going to let Tim leave him. And you see all the videos from the businesses and the neighbors. And you see the cell phone reports of what the defendant was doing on his phone. We will prove to beyond a reasonable doubt that the defendant wanted Tim dead, he carefully planned out his murder, and he executed that plan with deadly precision. And the defendant is guilty of first-degree murder. Thank you.
Thank you very much, ma'am.
No, thank you.
Hold on, we'll take, Klein, you ready to proceed?
Yes, Your Honor.
Go ahead, sir.
Thank the court, opposing counsel. Ladies and gentlemen, your day is almost done. Fear not. The state presented their theory of the case. This is my opportunity to discuss with you what the evidence presented in this case will demonstrate. That is, there were two different locations used by this couple. There was the marital home, which was on 3 different parcels of land. It was a rather large residence and property. And Tim Smith, Herbert Swilley and Herbert's adult daughter, who Tim had known and lived with for quite a long time, all lived together at that marital home. And in addition to the marital home, just a few miles away off of Lake Weir was this apartment. And it was not leased by both my client and Tim Smith. It was leased only in Tim Smith's name. And this was a place where these two men who were in an open relationship could take other men that they met on applications like Grindr, like Adam for sex. They didn't want to bring random men to the marital home or have random men around Jordan, the daughter, so they had this apartment. And yes, my client did use the apartment as well. At one point in time, he had a key, his own key to that apartment. But the evidence will show that in the weeks before Tim Smith's body was discovered at that apartment, my client had lost his key. He had no way to access the apartment during the time and date range that the state claims Tim Smith was murdered and his body was moved to that apartment. There was an application called Life 360. People can use it to share their location through their phone with other people that have the application. And Jordan Swilley, Herbert Swilley, and Tim Smith were all using Life 360 and sharing their location with one another for quite a long time. And in the months and weeks leading up to Tim Smith's death, Tim Smith more and more stopped sharing his location with them on that application. He did that because he didn't want them to know how much time he was spending at that apartment. Tim Smith was, by all accounts, loved by everyone who knew him. But like all human beings, he and my client were imperfect. They both wrestled with the disease of alcoholism. And Tim Smith was also a member of Overeaters Anonymous. And through the programs of recovery of Alcoholics Anonymous, AA, and Overeaters Anonymous, Tim was able to gain the tools to overcome those urges, those addictions. But what came in place of those things? The thing that replaced those things, at least for Tim Smith, according to the evidence that will be presented at the trial, is meeting people for sex at that apartment. It wasn't my client and Tim Smith who were playing out these fantasies at that apartment. It was Tim Smith. And the more and more that he was doing that, he was communicating with men on the internet and by telephone all the way up until the date that the state claims this plot for murder started. March 23rd, 2023. And because of this behavior, and because of what was going on at that apartment and how much time Tim was spending there and how much traffic was in and out of there, other people that lived in that neighborhood where the apartment was located began to notice the amount of vehicle traffic coming to and from that apartment complex. They also noticed at least one young white male with blonde hair who walked that neighborhood in the weeks leading up to Tim's body being discovered. And what happens after Tim Smith's body is discovered at that apartment? This extra vehicle traffic stops, and that young white male with blonde hair is no longer walking around the neighborhood. And yes, law enforcement did thoroughly process the crime scene where Tim Smith's body was discovered at that apartment. And lo and behold, on physical evidence, a bottle of personal lubricant and a sex toy, there were items of fingerprints and DNA that were of value. And they matched in databases to known offenders, to people with criminal histories. James True and Lloyd Kelly. And the state would have you believe that these individuals were thoroughly investigated and ruled out. But I submit to you the evidence and the lack of evidence presented in this case will demonstrate that's not the case. That Detective Pender, who was the lead investigator in this case for the sheriff's office, he's the lead detective. He's a major crimes detective. He's a good detective. But he had made up his mind that it was my client that did this. So much so that he pawned off responsibilities like interviewing Lloyd Kelly, one of the individuals who was in the apartment at one point in time, who admitted to having a sexual encounter with the deceased to his colleagues. Never spoke to them himself. And it's these kind of holes in the investigation that leave reasonable doubt. The detective and the state will rely heavily on an array of electronic evidence. Videos, surveillance from local businesses, surveillance from civilian video cameras, home security devices, Ring, etc. There was vehicle movement on the morning of March 24th, 2023. But no one knows who was driving these vehicles. The state will say, well, common sense. Use your common sense. But when we're presenting the evidence, or the evidence is being presented, whether it's by the state or by the defense, you will notice there is no witness that places my client at the apartment where Tim Smith's body was found, either on the night that the state claims that Tim Smith was poisoned, or early the next morning when the state claims that the vehicle movement was occurring and Tim Smith's body was placed at the apartment after he was killed at the marital home. To fill these voids, the state will present ample evidence of a motive. They'll talk to you about money. They'll present documentation about life insurance policies, about benefits that my client would have received upon Tim Smith's death. But the state doesn't have to prove motive in this case. They can present it, but it's not required to prove its charge. Does it go to premeditation? Sure it does. There was mention of Tim Smith's new job opportunity in Volusia County, and that he was on the verge of one of the final interviews to obtain that position. There will also be evidence presented that maybe he didn't care that much about the job as the state would want you to believe. He didn't even accept the invite for that Zoom interview. His prospective employer had to contact him the night before to remind him. Ladies and gentlemen, upon presentation of all of the evidence in this case, you will note that there exists reasonable doubt in this case, and that my client is and remains not guilty. Thank you.
Thank you, sir. So, ladies and gentlemen, we'll go into recess. You're free to go home. But leave your notebooks here.